Ever since Prop 19 passed in February of 2021, there is a severe limitation on property tax exemptions for transfers between a parent and child, and that's exactly what we're often dealing with when we do trust administration.
So, Tiffany, what is trust administration?
So trust administration, simply put, is to carry out the terms of a trust. Oftentimes, this is a trust that we might have created as a revocable trust, and someone has now passed away, and we are now helping the successor trustees, the people that were appointed to carry out the terms of the trust. We are helping them do so.
And when someone learns that they are the trustee of a trust, are there any immediate deadlines that they have, either a day, a week, a month, a year?
There are definitely statutory deadlines that are imposed by California law. Once a trust becomes irrevocable, beneficiaries are entitled to notice, and this notice has to have certain information on it for the beneficiaries. Those need to be served within 60 days of the death of the decedent. Then there are also notices to government agencies. There is a lodging of the will with the county court in the county in which the decedent passed away.
And these are not an exhaustive list of deadlines. There are also certain property tax forms that must be filed as well. Failure to do some of those, as we well know, can trigger a property tax reassessment.
Yes, especially ever since Prop 19 passed in February of 2021, there is a severe limitation on property tax exemptions for transfers between a parent and child, and that's exactly what we're often dealing with when we do trust administration. A parent has passed away, and now under the terms of the trust, the property is going to pass to the child. And if we don't file the proper paperwork with the county to preserve an exemption for that child, that property is going to be reassessed. And what follows are incredibly appreciated property taxes.
Once someone has decided they are going to serve as trustee, they serve these various notices within the statutory deadlines. What are the next steps after that?
So oftentimes when our trustee meets with us, what we want to do is inform them about their duties as the trustees. They have duties that of loyalty, that they need to act fairly among all the beneficiaries, and we advise our trustees about these duties and help them along the way through the trust administration process to be in line and make decisions in accordance with those duties. What also follows after we provide these notices is reviewing the estate planning documents so that we understand what the terms are that we are trying to carry out. We also want to ask our trustees to identify all of the assets that are either in the trust or that were owned by the decedent. That helps us determine the next steps in terms of how we get those assets transferred to the name of the trustee so that they can manage it, or to the beneficiary that might be listed on the account, or to the joint tenant, or sometimes we might have to engage in some sort of process with the court.
Yeah, so what does the trustee look for in determining whether or not this is an asset that they can just simply bring it into the trust versus perhaps some other process?
So what we ask the trustees to do is look for documents that evidence title. That's either going to be a deed for a property, or it's going to be statements for accounts, business documents, membership certificates, or share certificates perhaps for businesses.
And we often will do some deed research for our clients as well to find out how things are titled. Hopefully, those assets are all titled in the name of the trust, and then we can assist them with transferring those assets to their name as trustee of the trust. Once we have marshaled those assets and hopefully there is nothing that's going to require probate, what's the next step for the trustee?
So oftentimes during this administration too, debts and liabilities of the decedent will arise, and so our trustee's duty at that point is to assess whether or not they are legitimate debts, and if so, then the trustees should pay for those. The trustees also should do an accounting of the trust administration process, and what an accounting involves is basically providing all the information during this trust administration process. I often think of it as a story that begins with what assets did the trust begin with, what kind of disbursements were made from the trust. Were they expenses, liabilities? What assets were gained during the administration? Maybe assets were added to the trust because something was outside of the trust and now put back in. Maybe there was some income from accounts, rental income. Those things also need to be accounted for. And then at the end of the accounting would be what is left over available to be distributed to the beneficiaries.
That sounds like quite the undertaking to do a trust accounting. Does every trust administration require that the trustee provide an accounting to the beneficiaries?
No, in fact, a trust accounting is very difficult. It requires a lot of details to be included and oftentimes engaging a professional like a CPA or a firm to help them. So it can not only be very burdensome, it can be very expensive. No, they don't have to do an accounting. If the beneficiaries are willing to do so, they can sign a waiver of accounting so that the trustee doesn't have to do a full accounting of the trust administration.
When a trustee marshals real estate, obviously it's very difficult to just simply divide that asset among several beneficiaries. And so quite commonly, the trustee will decide to sell that real estate. Are there certain actions the trustee should take in advance of selling that real estate?
Perhaps if they want to be as transparent as possible with the beneficiaries, which we often advise, we want to do a notice of proposed action to the beneficiaries to let them know that the trustee intends to take this action and wanting to get the beneficiaries on board before they actually take that action. So we prepare a notice to the beneficiaries of the proposed action, give the beneficiaries an opportunity to voice their concerns, and if possible, get their consent before the trustee goes ahead and moves forward with it.
Yeah, the benefit of a notice of proposed action is that we get to learn at the outset, before we actually perform this action, whether or not a beneficiary is going to object. If they are going to object, then we need to advise our client, the trustee, on the next best steps, which oftentimes means petitioning the court to approve this action, or to address the beneficiary and find a resolution before we move forward, so that we can avoid a claim later on that our client has breached their duty in some way.
Absolutely. Definitely through the reason why our clients set up a trust is to minimize litigation, minimize contests. So if we can we can minimize the chances of doing so with a notice of proposed action, we definitely advise our trustee to go with that.
Well, once an accounting is prepared, how long does the beneficiary have to consent or object to that accounting?
Well, the beneficiaries have either 3 years or whatever the trust document says, but not less than 180 days to object to any accounting.
Yes. So oftentimes we are asking beneficiaries to consent to approving this accounting. But if they don't do anything, depending upon the terms of the trust, we can make distributions after 180 days. But sometimes, and we've had administrations where it can take up to 3 years before the statute runs. That is obviously not ideal. We would much rather than just petition the court to approve our accounting. The downside of petitioning the court to approve our accounting is it just requires more money, more fees, and more time. So ideally, the beneficiaries will just simply consent, or even better, just waive the accounting altogether if they believe the trustee has properly done his or her job.
At which point, the trustee can then calculate how much each beneficiary receives, and then we can make the distribution, which is what all the beneficiaries want.
Should the trustee keep a reserve when they're making distributions?
Absolutely. There are always unanticipated expenses that will arise after the distribution of the assets. That can be taxes that were unforeseen, that were uncalculated as of the distribution. So we always recommend that there is a reserve, and that's going to depend on where we are, maybe in the tax year, what other assets were in the trust. We can kind of estimate what might come in as an expense.
Yeah, there are often tax issues that are not yet resolved. The final tax return oftentimes is not filed because that may be on a calendar year or the fiscal year is not yet up. And so the beneficiaries want their money, but the taxes have not been finalized. So we often recommend keeping a reserve for that purpose,
Right.
and then making distributions thereafter.
And without a reserve, and if the trustee finds that they do have to pay these unanticipated expenses with no money left in the trust, they're going to have to ask the beneficiaries for the money back, and you can imagine how the beneficiaries feel about that.
What about trustee compensation? How much should a trustee take in compensation, or how do they determine what is their compensation?
Well, as always, we should first look to the trust document and to determine whether or not the grantors, the people who wrote the trust, has already determined what is a fair and reasonable compensation for the trustees they selected. And if the trust document is silent, or if it says reasonable compensation, then we look to what the county deems reasonable. And in Orange County, that's typically between $30 and $50 an hour for a trustee. If the trustee has any expertise in the law, they could demand a higher compensation that would be commensurate with what they would normally get paid in the practice of that particular expertise.
Yeah, you always have to be careful and check the trust document to determine what the trustee compensation is. There are some estate plans that I have drafted, and those clients have said, we don't want our children to be compensated for their time as trustees. If they're going to serve, then they're going to do it for free. If they don't want to do it for free, then someone else will serve as trustee. So you always start there and determine if the trust provides anything. If not, you're left with reasonable compensation under the code, and we can always discuss that with the trustee further. Anything else, Tiffany, you want to add for any soon-to-be or current trustees of a trust administration?
I think the task seems daunting. There is a lot of work to be done, and often it is work that is not appreciated. We try to help our trustees do this in the most efficient way possible, not only cost efficient, but time efficient way. And I think it is a thankless job, but it is helpful for you to have the advice and support of an attorney to get through the process.
It certainly is a thankless job. I do always tell my clients that it's an honor to be named to serve as trustee.
That's one way to see it.
Because the person that created this trust has entrusted you, hence the term trust,
Sure.
with performing his or her wishes. And I think that it can be a great honor, but it also comes with a ton of potential liability. And our job is to make sure that he or she does their job properly and avoids any potential liability.
I agree.
If you have any questions about trust administration, if you are contemplating serving as trustee or you are currently serving as trustee, feel free to reach out to us at Modern Wealth Law. Until next time, plan well, live well.